Um, obviously, if you have questions, we can kind of delve into more specific issues, but I was sent a few questions ahead of time to kind of the things that people specifically had questions about. So I'm going to try to address those issues very specifically, or as specifically as I can. Keep in mind, when you're talking about CPS policy, we do have some state policy, but how that's implemented county to county can differ wildly. Even within one county, if there's more than one judge, it can be very different in the same county just between divisions when you're talking about how cases are handled. Obviously, the Supreme Court does put out some guideline, but it doesn't answer every question. And so I know that there are some questions that I anticipate the Supreme Court handling very soon. And we'll kind of get into some of that. But generally speaking, just CPS law and policy is what I plan on going over today. The first thing that I think I know that there were several questions, were with the investigative stage. So obviously, when somebody calls in a referral, depending on what the content of that referral is, it's 24 to 72 hours to make contact. I've been told that the commissioner now is wanting the department to be making contact with that child within 24 hours of when the referral is received. But that doesn't mean that the full investigation is complete within 24 hours. It just means they've made contact with the child and assessed whether that child is physically safe right then. So if during the investigation it's determined, and I'm on the second slide now and about to go into the third, when there's an investigation and the department starts looking at, is there an issue there that needs more involvement, some court involvement, there are certain things that guarantee a removal from parental custody. One that I think a lot of you guys see, especially if you're working within the hospital setting, is a prior termination of rights when there is a new baby. Under West Virginia code, the department is obligated, meaning they have to file a petition requesting that the court give them custody of a newborn baby when either the mother or the father had a prior termination of parental rights. So that means they did not relinquish their rights. The court involuntarily terminated their parental rights. That necessitates a petition. Now, county to county, you may see some differences. I will say in Monongalia County, and Amy Farah is on this meeting, so she and I have a case that we filed, I'm going to say about 3 or 4 months ago. It was a mother who had a prior involuntary termination of rights. However, in the time between when that prior involuntary termination of rights occurred and when the new baby was born, she had gone to long-term treatment. She was still at the long-term treatment, and it's an excellent program in Huntington. She was doing everything she needed to do. And so we did file a petition seeking court involvement. We did not ask for custody. So that mother kept her newborn. She's doing all the things she's supposed to do, and there are eyes on. She is still in the facility. There are still eyes on. So we were able to ensure safety. That's kind of a rare case. There's another one that I did similarly recently. I cannot say that other counties will do that or they won't do that because I simply don't know. And I think a lot of it depends on the judicial environment of your county, whether the judge is going to be amenable to leaving a child in parental custody when there's the prior involuntary termination of rights. So, it kind of goes back and forth. So that's a guarantee in a lot of cases that there will be a removal. An unexplained injury. So
can I ask a quick question, Jennifer?
Absolutely.
So is there any kind of length on that? So say if it was 8 years ago versus 6, a year ago, or does it matter?
No, it could be 25 years ago. And yeah, so the department or this, I'm not even going to say the department, the state has a long memory when it comes to these issues. And I think I'm going to say something to keep in mind is we are all on the same team. I know it doesn't always feel like that, but we are. And it's to protect the best interests of the child. And I'll kind of get into that a little bit later. The courts are very reluctant to not take a child when there's been a prior involuntary termination. And the reasons for that are numerous. But I think a lot of people in this meeting probably can tell you cases where the department did not act sufficiently and a child died. And when that happens, everybody and their brother is sued. And I'm not saying that litigation is the only thing that prompts action, but it certainly does have a bearing. And frankly, no one wants to see a dead child. No one wants that to be the end result of inaction. And so when there's been a prior involuntary termination, everyone is on high alert, because we have had really terrible results when we didn't act sufficiently. So no, yeah, there's no time limit on that. So another thing that will pretty much always guarantee a removal is an unexplained injury. And I'm not talking about one little bruise or anything like that. A case that I have right now that some of you may have some familiarity with is a 2-year-old child who was covered in bruises head to toe, facial, all over his body. Nobody can explain what happened. And so that's a removal. And I think somebody just had a question in the chat.
Yeah, I'll read it for you. It says, does that still apply if there's a new baby with a different partner who has not had their rights terminated?
Yes, it still applies. Now, let's say mom had a prior involuntary termination 3 years ago, substance abuse didn't address that issue. So she was involuntarily terminated. In that time period, if she got with a new partner and that's the father of this baby, if the new partner has no CPS history and appears to be fine, like they go take a drug screen, their drug screen is clear of all substances, they don't have anything in a CPS history, the department can put into place a plan where the parent who has the prior involuntary termination is not living in the home. And the parent who doesn't have any of those issues can have custody of the child. And then the parent who does have history can basically be in an improvement period. I understand that's not ideal, but it's reality. That's how it's handled, not infrequently. I will say it's really rare. I can probably count, I've been doing abuse and neglect work since 2006. I could probably count on my 2 hands how many times I've seen that situation, and it probably wouldn't take all my fingers. And that's with thousands of cases. So, I mean, it happens. It's just not super common. Another thing that will necessitate a removal from custody, parental substance abuse. So I'm going to speak to Monongalia County. And I know that there is a difference between counties in the state. And at some point, I anticipate the Supreme Court addressing this issue, but to date, they have not. For Monongalia County, when we're talking about parental substance abuse, we're not going to remove a child for cannabis use. It can prevent a reunification, and that is not my choice. Our judges tend to take a very dim view of people using THC when they're in an improvement period. And I just had a judge very plainly on the record last week, I for the department, we said we did not feel that this issue should prevent reunification. The judge made it very plain she would not allow reunification if the parent continued to use THC. So I understand from a medical standpoint that very few providers would feel that the usage of THC should prevent a parent from parenting their child. I get that. That is not the current state of the law. With that being said, in Monongalia County, we are not likely to remove a child for THC use. There would have to be some other circumstance with that. However, if a parent is using, say, methamphetamine and fentanyl, and they go to treatment, they stop using those substances, but they continue to use THC, if that is not THC usage with a medical cannabis card, it can prevent reunification. So that's where we are right now. Like I said, I anticipate the Supreme Court probably issuing something on that if our legislature does not do so prior. And by that, I mean, I know every year right now it's coming up, somebody will present a bill to allow recreational cannabis use. Although even once you do that, I guarantee there are going to be several judges around the state who will still prevent reunification if people test positive for THC. So that's kind of where we are. But generally, when we're talking parental substance abuse, methamphetamine, fentanyl, heroin, things that we all can pretty much agree they affect one's ability to parent your child. Gross neglect resulting in physical or emotional injury, physical abuse, severe emotional abuse, and there can be a whole lot of other reasons, just depending on facts and circumstances. So moving on to the next slide, there are two different types of petitions that can be filed in abuse and neglect. One is an emergency petition, and that's kind of what we've been talking about when the department is going to take custody of a child or children. That's an emergency petition. So the department will take custody of the child. They have custody through a ratification frequently, and then an initial order. Following entry of that, we have a preliminary hearing within 10 judicial days where the court determines whether or not there was probable cause. Almost without fail, a probable cause finding is made. I've known one case ever in my practice that probable cause was not found. And that was because the person who called in the referral came to the preliminary hearing and testified that they had falsified all of the information contained in the referral. So that's very rare. The other kind of petition is a non-emergency petition. That's where the department does not take custody. That would be in the same kind of situation where, like, there would have been a prior involuntary termination of one parent, but the other parent does not have that impediment. So whenever you can leave custody with a parent, you can file a non-emergency petition. That's also what happens when it's what we call like a dirty house case, where it's just, deplorable conditions, things like that. A lot of times that's a non-emergency. So in that instance, you would not have a hearing in 10 days. It would go straight to what we call the adjudicatory hearing, which is kind of like the trial of the case. And that's within 30 days of filing the petition. The next slide, going on to that. So the court process generally, what happens if it's an emergency hearing? Like I said, you have the preliminary hearing. If it's a non-emergency, it goes straight to adjudication. From that point on, the process is the same for the two different types of petitions. So you have the adjudication within 30 days after the preliminary, or within 30 days of filing it. That's the trial. Not infrequently, parents stipulate or they admit to certain conditions that would justify court involvement. So I'm sure everyone's seen the numbers. The vast majority of abuse and neglect cases now are based upon parental substance abuse. That's just a fact most of the time. Somebody is taking a drug screen, they tested positive for methamphetamine. They're going to stipulate, yes, I've used methamphetamine. It's affected my ability to parent my child. I understand that I'm going to need to participate with the court to show that I'm dealing with this issue. If they do not stipulate, we have basically a trial and we present testimony and the court makes a finding. It is a lower standard of proof than in a criminal trial, and the criminal trial rules do not apply. So, like the right to remain silent doesn't apply in abuse neglect. And in fact, if you're called to testify and you refuse to testify, the court can make a finding that you would have, if you had testified and told the truth, you would have confirmed the facts in the petition. So that's the negative inference that can be drawn, and people don't always understand that. So it's a different world than in the criminal system. And it's exceptionally rare that when the department files that the court doesn't make a finding. After the trial or adjudication, there's an initial disposition. Sometimes it's held concurrently with the adjudication. Sometimes it's held about 45 days after. That's when a parent can request an improvement period. And there are 3 different kinds of improvement periods. The one you would have had before the adjudication, it's called a pre-adjudicatory. It's 90 days. It cannot have an extension. And most attorneys and judges are very loath to grant a pre-adjudicatory unless it's that very rare circumstance where it's an issue that we all know can be corrected in 90 days, or like the parent who had a termination 15 years ago and they since got clean and sober and they're doing well. In that instance, we might do a pre because we know that things are generally going well. Most of the time, you're going to have what's called a post-adjudicatory improvement period, which is, it starts out at basically 6 months. It can be revoked. It can have a 3-month extension. And then there's what's called a post-dispositional improvement period, which is another 6 months subject to another 90-day extension. So if needed, we have about 18 months to address these cases. You can extend it under extenuating circumstances, and that does happen on occasion, but it's pretty rare. Most of these cases resolve with the parental aspect of it in under 2 years. After 2 years, we have those cases ongoing to achieve permanency for the children if rights are terminated, or if what's called a disposition 5 is granted, where the rights are not terminated, but the parent does not have custodial rights. That happens a lot of times when a parent doesn't address the issues in the case, but another family member has custody of the child. So like grandma or, dad or mom or whoever. And then the end result with parents, we look at final disposition. The preferred result in every case is always reunification. It's statutorily what we have to seek. And frankly, most people who do this work, we want to reunify families. That's the goal. It's not happening all that often. Right now, I would say maybe 25% of the time. And somebody just asked a question.
Yeah, does the parent have the option to get them back after disposition 5?
Yes. So if a parent gets a disposition 5, they can petition the court to modify the disposition 5. I'm seeing more of these than I did 10 years ago, 15 years ago. And that's really promising to me because that tells me people are getting better. We're operating in this really short period of time. And I think everybody here recognizes that substance abuse is rarely something that people are able to address the first time they try. And it not infrequently takes years to really address the issues. So I had not seen a successful modification of a disposition 5, probably the first 8 years I was in practice. The past few years I've seen more. And I like disposition 5s when a parent is legitimately trying and the child is winding up with another family member. I think it's an appropriate resolution. It is not a preferred resolution for the court system because there are people who would argue it's not real permanency. Under code, it is permanency. As long, the other person can get a legal guardianship if it's a family member. It just doesn't allow for an adoption. But I am seeing people who are addressing their substance abuse issues. And I guess kind of the scenario that I have in my mind a lot is when parents have substance abuse issues, kids go to a grandparent, but they have some level of contact with their biological parents ongoing. They never call grandma mom. They know who mom is, they know who dad is, they have an ongoing relationship. If that parent's able to do better later, I think it's a good thing that they have the option to go back to court to seek a modification. Now, when they do that, the burden is for them to show two things. One, that they've addressed the issues that led to the disposition 5 in the first place. The other is that they have to show that it's in the child's best interest to modify that disposition 5. That's the hard part. To be able to convince the court I should have custody when I haven't had custody for the past 5 years. What I see a lot is if it's going to modify, it doesn't necessarily give them back full custody, but it opens them up to basically like a visitation schedule is what's more likely. Now, I did have one where the grandparent passed away and the parent had addressed the issues, and so they got custody back. And I saw that there were a couple of other questions.
Yes, so Jessica had asked, does it matter if it has been a couple years? And Shauna, thank you for answering. She said, depends on the situation. These are very fact specific.
And the length of time doesn't matter. As long as the child is under 18, it can still come before the court. It can be 12 years later, it can be any period of time, but it is very fact specific. And we'll kind of get into that. Some of the questions that I got ahead of time were basically, and I get it because you guys are coming from a medical background, or a lot of you, where there's a protocol for if X, then Y, then Z. These are very fact specific scenarios with a lot of moving parts. And so I'm going to give the lawyer answer is always, it depends. And that's true. It depends all of that on the situation. And I'm going to go ahead and move on. And I guess for the final disposition, so reunification, preferred result, dismissal with services, where the kids are reunified with the parents, but we keep services in place for the family for a period of time, usually about 3 months. A disposition 5, or the termination of parental rights. Moving on to the next slide. So we're probably going to spend a decent amount of time on this. And if you have questions, throw them in. This seemed to be what people had the most questions about that I got ahead of time. And that was about visitation. And I'm going to start out with the lawyer answer. It depends. Everything depends. There is no guaranteed amount of visitation anybody's getting. There's no, once you've done X, Y, and Z, you get this many hours. I wish that would be how it worked, but frankly, we do not have the manpower to actually implement that. So ideally, when a petition is filed and we've taken custody, ideally, visitation is set up prior to the preliminary hearing. And that happens a decent amount of the time. Sometimes it doesn't. And it's not because anybody just doesn't like these parents or whatever. It's usually because there's not a provider to be able to actually supervise the visits and do the transport. And part of that is other parts of the state might have an easier time with this in Monongalia County, but I can say that in Monongalia County, we do not have a ton of foster homes within a close area. So a lot of times the foster homes that we have are hours away. Logan County, Mingo County, Cabell County, Putnam. And as you guys all know, a lot of times the parents that we are working with don't have transportation. And so we have to figure out a provider who's able to transport parents or transport children. We also, with little kids, we don't want to make them have a 6-hour round trip for a 2-hour visit with mom and dad right after a traumatic removal. Everybody's trying to do the best thing for the kids and also provide the visitation. So visitation is generally supervised by third-party providers. I will say CPS workers have really been stepping up, in my opinion, and trying to arrange for them. They will supervise the visits if we can't find somebody else, but that's still a lot of moving parts. I've even had guardians ad litem the children's attorneys supervising visits just to make sure that parents are getting a visit and kids are getting a visit. But again, there's no set amount. Usually it starts out at like a 2-hour visit and then it increases over time. There's no set amount per week. With newborns and really small kids, we try really, really hard to have frequent visits because everybody understands you need to bond. And I get into this a little bit more later, but something to keep in mind, and I was in private practice for several years. I had clients, and I'm sure you guys are in a similar position. I learned that I could not always believe what my client told me. And so sometimes your patient is not being fully transparent with you. And so I hear a lot of times, well, my doctor says X, Y, and Z. Well, you obviously didn't tell your doctor that you canceled 5 visits last month. Do you see what I'm saying? So sometimes on your end, you may be getting one version of fact or reality that is not necessarily consistent with what the court system is seeing. By and large, people are getting their visits. I understand there have been cases where people maybe are not getting visits when they should, and we try to address that. Amy, who's on here, can attest. We work on that, and the courts yell at us when visits aren't happening. So nobody wants to be yelled at by the judge. Generally speaking, CPS workers, at least the ones that I work with, are very good about setting up the visits. And if visits aren't happening, there's usually a reason for it. I'm not going to say that that's 100% of the time, but I will say the vast majority. Moving on to the next slide. I had a question about how a parent could advocate for themselves in regard to visitation. So as soon as a petition is filed and parents are served with a copy of that petition, they should be reaching out to the CPS worker who is named in the petition. The name is in there along with the phone number. They need to reach out to that person. They need to reach out to their attorney who has been appointed to represent them. And ideally, if I were a parent in a case, I would reach out to the guardian ad litem, because the guardian ad litem represents the children and the court listens to what the guardian ad litem says. So when a parent reaches out to that guardian ad litem and says, what do you want me to do? And then they follow through with that, they have another advocate for them sitting in the courtroom beyond their own attorney. And that does a lot of good. So, that's the best way to handle that. You can just call these people. They can talk to them at MDTs. I definitely recommend calling them, though, outside of the MDT, because a lot of you have participated at MDTs. They're usually 30 minutes or less. You're not going to address in-depth issues, and that's not the time to kind of present your case. That's the time to work out problems. These parents need to be contacting the worker and the GAL prior to that MDT to figure out what they need to be doing. They have legwork that they need to do. The obligation is not on the department to pave the way for them. They need to do some of this work on their own too. So I think I've probably addressed the second part of that about what's the timeline to set up visitation. It's as soon as possible. Everybody's trying to get that set up as quickly as we can. Now, another thing, if they've had visits and that's curtailed, there's a reason. It may not be that their drug screens were, that they showed that they were using. It could be that they did something during a visit that was really problematic. They may have said something to the child that is a problem, or something could have come up like that, which happens not infrequently. moving on to transportation. A question that came up was, what is the department's obligation for getting people to visits? The department doesn't really have an obligation with that. The department will work with people and they will work with them to give them a ride, but especially if it's local, if the idea is they need to come to the department for a supervised visit, they need to figure out how to get there. We have buses, people, that's part of that adult life skills, is figuring out how you get yourself to places. Sometimes people are able to get bus passes, so they're not having to pay for bus transportation. A lot of times when parents are working with a parenting or adult life skills provider, that person will even drive them to visits. I've had CPS workers who will go pick people up and drive them to their visit. But they need to be communicating with these people to make sure that that's being arranged. All these workers have a lot of cases. To give you some idea, when I started out as an assistant prosecutor in 2012, I had fewer cases than I have now as a part-time prosecuting attorney with 1/3 of the cases in this county. And in 2012, I had all the cases in the county. So we have about the same number of social workers, but their caseloads have tripled, quadrupled over the past 10 to 12 years. And so they don't know what a parent needs in terms of transportation unless that parent is communicating with them. And they can't wait until the day of the visit and call an hour before and say, I don't have a ride. Can you come get me? The workers are in court for sometimes 6-7 hours a day, in addition to doing home visits and setting up services and all of that. They need time to figure out in the schedule who can do that. So obviously part of what I'm saying is people need to be an active participant in their case, and they need to be actively communicating with the worker, with their services providers, their attorney, and the guardian ad litem. If they're not communicating with people, no one knows what it is that they need. And this slide, moving on, it's slide 9. I have a feeling people are going to have some discussion points on this one. My patient is testing negative on urine drug screens and isn't having visits. What's going on? So county to county, this varies wildly. In Monongalia County, again, we generally set up visits regardless, unless a parent has done something during a visit that affects our ability to ensure safety during a visit. They're going to have visits whether they're testing clean or not on drug screens. Preston County, so 30 minutes away, totally different story. If people are testing positive on drug screens, including for THC, Judge Schaefer has said no visits. I'm not going to say that's every case, but I know it's a significant number of cases. And his general rule has been that parents need to be able to provide 2 weeks of clean drug screens prior to having a visit. And if they have a screen with substances in the interim, those visits will be stopped. And somebody commented that Randolph does not allow a visit with a positive result. So again, it varies county to county. And I think another thing that is coming up is if they're having clean urine screens through their, like if they're at the Coke clinic, but if they've had screens showing substance use through the day report center, there could be a problem there. I don't have the answer for that. That's one of those issues that I'm very anxiously awaiting the Supreme Court to chime in on. But for right now, that's just kind of the situation. And I don't know how to answer that. I will say, the day report center, at least in Monongalia County, uses urine screens, blood spot tests, a patch. And I think I've covered all that. Harrison County, I know, uses hair follicles in addition to those others. Somebody commented, or administrative positives if they're not showing. And that's also an issue. Like, even if they're doing all of your urine drug screens through your clinic, if they don't show up for the court order drug screens through day report, the court makes a finding that those would have been positive. So people can't be skipping their day report screens. If it is impossible for them to make day report, if they're also doing, say, the Coke clinic and they also work, that's something that their attorney needs to address with the court. You know, the department can't just say, okay, you can skip those. They're not allowed to say that. There's a court order in place that they do those screens. So the attorney for the respondent has to address that with the court as to how that's going to be handled. I think that covers everything on that slide. Does anybody have any questions about that, or?
Actually, Jennifer, I'm going to ask you one question just while we're on the topic, because I bet these people are seeing this a lot too. I all of a sudden have had a lot of clients with very believable people backing them, saying that they're going to day report, they're going to probation, wherever they're testing positive. The person with them, you know, or they know that that isn't accurate, they're going directly to a hospital or somewhere else and getting a negative test. And I've actually talked to a couple of the doctors who sit on that review board saying that they're seeing this more and more, and that there are certain tests the state's using that are highly inaccurate. So how have you dealt with that, and how have you seen people deal with that?
So that's what I am hoping the Supreme Court addresses soon.
That's what I was wondering, if that's what you...
And hear me out. So it's a problem when everybody is not on the same page with that. And it makes it very difficult. I don't know. All that I can tell you is I've sat through at this point hours of testimony. And when I say hours, I'm probably at over 100 hours of testimony in the past year from doctors, scientists, you name it, about drug screens. I am exhausted from debating the accuracy of drug screens. I went to law school. I don't balance my checkbook. I don't do math. I don't, like, this is not, and so I think I'm not in a position to make a finding as to scientific accuracy. Our judges have heard all of that testimony, and I will tell you, in Monongalia County, it is established that our judges are accepting the validity and accuracy of the blood spot test, which seem to be the issue that is the most volatile at this moment. That's all that
I mean, do you mean even when there's a contradicting
yes
test? Yeah, that's where my question basically you answered was, do you think the Supreme Court's going to address that? Because I mean, it seems to be a big problem, because I find it hard to believe when I have, a lot of people who are working for a facility who have no reason to lie, saying, I know this person has tested clean every day in our program for the past 6 weeks, and then they're taking him directly to the hospital after that positive screen and it's negative too. I find it hard to believe that that one test is more accurate than all that other information. So,
well, and here's what I will say about the blood spot test. And this is what I've heard from lots of testimony. I do not shoot the messenger.
Yeah. Oh, no, I know.
I'm conveying what our judges have heard many, many times. The blood spot test generally, and the urine test that Day Report uses, are testing for much lower levels of substances than what the hospital is testing for. And I know that because I've looked at the tests.
And honestly, I don't think most of the clients I'm referring to are using that blood spot test, to tell you the truth, because most of my clients I've had that happen is in Harrison County, and that's not the test that they're using.
And I don't know. I know that Harrison County is using urine and hair follicle. I know they discontinued the use of the patch in Harrison County not that long ago, like just a few months ago. I don't know. Like all that I
know. And I'm more interested from you in if the Supreme Court It's gonna address it,
So
yeah.
I've had, and one of these came up within the past couple months. So there was a person who tested clean on their urine screens through the Coke clinic. They tested positive through, I think it was a blood spot test through day report. They denied using initially. Everybody on their team from providers was like, I know this person isn't using. I know for a fact they're not using.
Mhm.
Guess what? They were using. They admitted later on, yes, they were using. So,
Well, the couple of clients I had were, what makes it even more interesting to me is they were all in residential facilities. So,
and it can still happen. I had a
yeah,
residential facility not that long ago have to send everybody a letter that someone put meth in the coffee maker. So at the facility
yeah,
and
that might be true.
facility. So, you know, there,
I don't know
I'm
either
not
is the
saying I
my
don't
question.
believe-
I just hope the Supreme Court addresses it because I've seen it enough to the point where I think that there are a lot of times the client's lying, but I think there's sometimes I've had two clients that I really don't think they were lying.
and that could be the case. And I don't know. All that I can
Yeah.
say is I'm
Like I
hoping
said, it wasn't
desperately,
blood spot. Yeah.
like I can't tell you how much I am anxiously awaiting the Supreme Court
Yeah.
to just issue something saying, yes, we accept these screens. No, we don't accept these screens, because I am truly,
Yeah.
I probably on average am spending 2 hours a day right now just saying, I can't do anything about that. You know, this is the
Yeah.
drug screen. I can't do anything. So hopefully the Supreme Court issues something soon. And somebody just asked, so if the Supreme asking, is the Supreme Court going to be enough? And specifically, I'm talking about the West Virginia Supreme Court. I do not anticipate the United States Supreme Court weighing in on this. But yes, if the Supreme Court flat out says, we will not accept this screen anymore, that's the end of that screen. So the individual circuit court judges have a great deal of discretion in abuse and neglect cases. Like that's kind of one of the, like they just have a lot of discretion to overturn an abuse and neglect ruling. You have to have an abuse of that discretion at some level. So we've got a wide variety of like viewpoints when it comes to that between circuit court judges around the state. I wish that were more consistent. And as to when we expect a decision, I have no idea. I was told about a month ago that it had been requested that we get some sort of administrative decision on that. It hasn't come out yet. So I'm crossing my fingers. It will make my life much better if I just have something definitive one way or the other. And I don't know. I mean, that's all that I can tell you. It's an issue that everybody's dealing with right now. And unfortunately, I don't have a good answer to it. I wish I did. But right now we're just having to wait until something comes out definitively. But at least in Montague County, our judges have across the board just said, these are the tests. We trust the tests. End of discussion. And I've let people know, like, feel free to bring in expert witnesses. Like that's your right. I'm not arguing with you about it. Like you could present testimony and maybe you'll turn the judge around. I don't know, but ultimately that's going to be up to them. Another question that came in was, when can a child express their own desires in a case? And I think there's probably a little bit of confusion here, because in family court, generally speaking, at 14, a kid can say what it is that they want. And as long as it's not inherently harmful to them, i.e. they want to live with their parent who is addicted to something because that parent lets them do whatever they want, the court generally is going to go with what an older child wants. In abuse and neglect at 12, a child can participate in the case, meaning that they can come to MDTs, they can come to hearings, things like that. I don't encourage that unless a kid is older than 12, or if the circumstance of a case are such that it makes sense for them to be there. And the reason is, we talk about things in hearings that frankly, I have 3 kids of my own. I wouldn't want them to be in those hearings a lot of the time. But sometimes it makes sense for a child to be a part of that. And when it does, they can come and they can say what they want. At 12, they can participate. The court is under no obligation, despite a child's age, to take their wishes into account in an abuse neglect case up until 18. So at 14 in a family court case, they can be taken into account. In abuse neglect, the court doesn't have to take any of that into account. Now, in terms of a termination, if a child is older, and generally speaking, 14-ish, 16, if they do not want their parents' rights terminated, the department will not ask to terminate rights, or they're not supposed to. I generally work with CPS workers for any kid who's in the 12, 13, 14 range. I ask them to talk to the child, or ask the GAL to talk to the child. If a child of 12 really does not want their parents' rights terminated, and especially if they're in a family placement, I don't like to terminate those rights. I think a child kind of has a say there, but that's also going to vary from county to county. And I can't speak to what anybody else is doing there, and I can't speak to what other judges will do. Judges have also terminated rights over the department saying we're not asking for it. So, that's another, it's discretionary. And if they find that that's the appropriate thing to do, that's what they're going to do. So that's kind of, does that answer that question? As far as like when a child's view should be taken into account, does anybody have anything else on that? Alrighty.
I saw you had your hand raised. I didn't know if you had a question about that or something in the previous slide, but I wanted to give you an opportunity to ask a question if you had one. I think Jessica Calloway, you had a question. I don't want to put you on the spot, but I wanted to give you a chance to ask your question if you had one.
I was just going to ask the same thing Shauna was asking about, where we have patients that will send their urine to the lab at the hospital here, and everything will come back negative. Confirmations will come back negative, but yet the courts are still using the positive screens that they had at community corrections.
Yeah, I mean, as for right now, that's just how it's being handled. And hopefully we get some guidance from the Supreme Court soon.
Yeah, we have one patient that they've removed her children from her due to one of the false positives that they had at community corrections.
Yeah. And I mean, I will tell you right now, the court will not see that as a false positive. The court's looking at it, the levels that they're testing for. And I will say, as a prosecutor, I believe that those tests are probably accurate that we've got. With that being said, I think they're too sensitive. I don't like how sensitive they are, because I think that there's a potential there, not every time, but there's a potential for what I consider environmental exposure that can affect those tests. And I don't know what to do about that. I've advised people, please don't hang around people who are doing drugs, because that can affect you. Now I've had testimony from lab directors stating that in order to get a positive from environmental exposure, that you would basically have to run your bare hand through visible methamphetamine or cocaine or whatever, that they'd have to have that level of exposure. I don't know. I don't know. Like I said, I'm not a scientist. I'm not a doctor. I don't that's not my bailiwick. And I just wish, I'm very hopeful that the Supreme Court will soon come out with a guideline or whatever saying this is what we accept. We don't accept this test. And I think that will make all of our lives much better. So if anybody has a connection to the Supreme Court or the legislature, use it so that we get some guidelines on that soon, because I think we would all really appreciate it. Another question we got was, what happens if parents move? So we are obligated to file the petition where the abuse occurred and or where the child resides. If parents move, it is very infrequent that the court case will move to another county. Now, the services can move to another county. So like if I've got a couple or a parent in Montague County, and then they decide that they're going to relocate to live with family in, say, Raleigh County, and just the parents are going, the kids are somewhere else, the court will allow us, and the department generally just does it on its own. They'll move like drug screens to the county that the parents are living in. They'll arrange for a services provider to work with the family where they're living, things like that. But the case itself will stay in the county that it has been in. I have had cases be transferred between counties, but like I said, it's pretty rare. I've probably had 4 over many years that have transferred counties, but generally speaking, it stays where it is. Now, what I've had happen more frequently is when like people lived in a different state and they had prior CPS and court history in the other state, and then they're traveling and something happens while they're traveling. And so we file a petition here, and then they do not intend to stay here. They intend to go back to wherever it is that they were from. And so the judges will communicate, and there will be an order transferring that case to where they originated. That I've had happen more frequently. But it's pretty rare to transfer the jurisdiction of the actual case. Where we're right on the border, we get a lot of cases that have ties to Pennsylvania or Maryland or Ohio even. But generally speaking, those cases stay here until completion unless there's some extenuating circumstances that would warrant it going somewhere else. But going between counties is pretty rare, at least in my experience. And so my final slide, and then you guys can pepper me with all of the questions you want, and I will do my best to answer them. How can providers better interact with the department, the court, and just the process in general? I'm going to go back to what I said earlier, which is that we are all on the same team. And I know it doesn't always feel like that, but we truly are. The department relies very heavily on medical and therapeutic providers. And it's important, I'm going to be working with you guys presumably for the rest of my career. And I don't want to have a bad relationship with you. I want to have a good relationship with you. And I think department workers even more so want to have a good relationship with you, because they're the one having the face-to-face contact with you on a regular basis. And like I said, we're all on the same team. Nobody wants to put a kid in danger, ever. We all want to reunify families if it's possible to do so safely. And I think the difference is the department is usually coming at it from, they know all the history, and it's hard to forget history. And they know things about a family sometimes that you guys may not know, and they can't tell you those things. And you're obviously going to be advocating for your patient, and everybody understands that. And you're seeing people working, when they're working with you, you're seeing them trying and working. And I don't know how to open up communication. I wish that everybody could speak openly, but we've got HIPAA and we've got privacy, and that makes it a little bit difficult. But I would just say, keep in mind, we're all looking for the same goal. And if you feel like you're being met with resistance, you might just want to ask, like, is there a reason why the department is hesitant here? Just ask, and they'll probably tell you. but we're all trying to reunify these families if it's possible to do so safely. And so I think generally speaking, we're all trying to be on the same page. But we're also all overworked. A statistic I've been trotting out a lot lately is in the year 2000, there were 12 abuse and neglect petitions filed in Monongalia County. So I'll say that again. In the year 2000, there were 12 abuse and neglect petitions filed in Monongalia County. Last year, I think we filed 264. So it's a lot. And it's very frustrating. And frankly, it's frequently disheartening. But we're all looking for the same thing. I love it when I get to reunify families. It honestly makes my day. Every morning when I'm dropping my youngest off at school, there's a mom who's usually about 4 cars in front of me that we had custody of her kids for about 18 months, and she got better. And it makes me smile every morning when I see her dropping her kids off at school and opening the door. One of her daughters is in dance with one of my daughters. And it truly, like, it makes my heart feel so happy to see that worked out and she's thriving and her kids are thriving. And that's what we all want to see. So do any of you guys have questions or comments or complaints?
And say, Jennifer, this might be too much for you to talk about, but I think one thing that we didn't mention here that might be a little bit important is to explain the pre-petition process, because a lot of their clients might have CPS contact pre-petition, where that's where more of the important work can be done to avoid removal of your children, right? Because I think it's important to explain that not every CPS contact results in a petition.
Oh, absolutely. It's actually a very small minority of CPS contact results in a petition. So I'll tell you guys what, I'm a lifelong West Virginian. I have a very stereotypical West Virginia family. So of course I've had 2 cousins involved in the abuse and neglect system, not in my county. I'm from the southern part of the state. The advice I gave them when they called me after CPS got involved with their family is do everything they tell you to do. They're not going to ask you to do anything unreasonable. They want you to drug screen. They want you to do services. And if you do those things and you're doing what you're supposed to do, they want to be out of your life. I've never met a worker who liked filing a petition. I've never met a worker who liked taking people's kids. It's usually a really bad day for them when they have to do that. These are not overly burdensome requirements most of the time. And they're trying to avoid having you in the system for a long time. So the more resistant people are to screening or to doing basic parenting services, that's going to be problematic for them in all likelihood. But the department's usually pretty good about, if there's a possibility to put services in to avoid a removal, they're going to do it. So does that answer your question at all?
It wasn't a question. I just wanted to make sure that everybody understood that, most of your clients that have CPS contacts are getting a lot of chances before. So if you are seeing them and discussing those things with them, I just wanted them to have a background to know, the things to encourage their clients to do. Because that
Absolutely.
really, I think, is the more important portion of it. If, some clients are just, they don't understand, basically. Most of our parents don't understand. If they cooperate, there really probably won't be a petition. Or, if they do get in the services, or if they're supposed to be getting services and they're not getting services, they need to reach out, to multiple people, not just sit back and let those services not take place. And because in Mon County, it may not be a problem, but trust me, there's a lot of counties where services are supposed to be in place and they're not put in place. So, if your clients are telling you they're not getting those services, that might be time to reach out and try to help them figure out how what's going on and how to get that in place. So I just thought it was important for this group, particularly who can counsel these people before the petition's filed, that this is an important time for them to really step up and
Mhm.
be on their toes about what's happening to them.
Absolutely. Like, we've got one judge right now in Monongalia County who does a really good job of making sure that parents know you have obligations and you can't just sit back and expect everyone to bring all of this to you. And if something isn't happening, it's on you to call and make those calls and figure out, what do I need to do? Generally speaking, the department's pretty clear, at least in my experience. And like I said, I don't work in every county. I can't speak to what's happening in every county in the state. But, the department's pretty good about laying out, you're going to need to go here for drug screens. You're going to need to work with a services provider who's going to get in touch with you. You need to do this, that, and the other. But it doesn't mean that somebody else is going to facilitate all of that. Generally speaking, a lot is facilitated. But people still have an obligation to be a grown up, and you still need to do some of these things. So if you can talk to a client who's getting that kind of like pre-petition work with CPS, just to encourage them, this is the time to show up. You might be able to kind of slack off later, but for right now, you need to be on your game and you need to be making the phone calls and going to the appointments and doing the things to avoid having to deal with CPS for the next 18 months.
And
I
if
feel
you
like
need resources to allow your client to do that you don't know about, feel free to reach out to me. That's part of what my program does, or what I do, because I am the program. But I connect people with, if you feel, I saw in the notes somebody talking about a peer support specialist. I know a lot of peer support specialist groups that I've worked with. So if you feel that would really help your client, but you don't know how to get one, please email me. And I will put you in contact with anybody I know who can help.
Yeah, I think this is really helpful, and it's helpful to know those resources as providers, because I think, working with parents that go through this, I think when you're emotionally charged, it's so hard to remember all of this information. And it's so hard when you have all of these hoops to jump through and you're already dealing with these with your own recovery and an emotional flood, right? It's like getting bad news at the doctor's office, right? Like your mind goes to one place and then you kind of lose the rest. So I think it's really hard, and it's really helpful for us to know this information so that we can help support that.
And also I do through my program, and this is a little bit why I wanted to come today, is to promote this part of my program. Is I may not be able to represent somebody if they have appointed counsel, but what I can do is, if they don't have appointed counsel yet, if they're in that petition phase, I am more than happy to answer their questions and help them, point them in the right direction. I think, honestly, that's probably been the most productive thing I have done in this program, was to be able to meet with clients who are in that pre-petition phase and just help answer their questions and tell them what to do. The other thing I can do is, if they do have an attorney, I can ask their attorney if they don't, if they mind if I speak to them, or if they're having a huge problem with their attorney. I can't necessarily talk to them about their case without their attorney's knowledge, but what I can do is tell them how to request a new attorney if they really, really are having a huge problem. And in some counties, that's usually not an issue. I don't know if Mon County has that issue. They might have good attorneys, but some counties don't have good attorneys, and sometimes it's necessary to ask for a new one.
It's a struggle. I mean, I'll be the first to say, this isn't an area of the law that a lot of people want to go in.
Mm-hmm.
I did, because I probably have a chemical imbalance that made, I'm joking.
Oh, me too.
Like,
we're suckers for punishment.
Yeah, like I was one of those people that watched Law and Order SVU, and that's what I wanted to do. I never had the dreams of like big corporate law. But
Me too.
not a lot of people want to go into this. And so, especially like in Mon County, we're pretty fortunate. We have a lot of lawyers here generally. A lot of people would say we have way too many lawyers. But we do have a lot, and most of our panel attorneys for abuse and neglect are competent. I'm not going to say 100%, but most, and I do a lot of my own appointments, and I try to make sure that the attorneys in my cases are all good attorneys for folks. But I understand that we do have
Stuff
areas of
happens.
the state that don't have a lot of lawyers. There's one
Or
county
stuff just
that-
happens. I mean,
Yeah.
I had one case that I was shocked when I started digging into it because somebody told me I can't get a hold of my attorney, and I knew this person and I knew them to be a competent attorney, and I found out that she had her own issues and had just like not told her clients that she was out. So these several clients went for months without an attorney as she didn't tell them that she was having her own personal issues and just kind of checked out for a few months. So, I mean, stuff happens. So, you know, a lot of times the clients may not be getting along with their attorney because they're being difficult, but there are rare cases. So you do have to listen to your client and really read between the lines as to whether it's that situation or not.
I hate to interject really quick, but we do have a question with Jennifer over here. She's had her hand raised, so I want to give her that opportunity.
Hi, everybody. I logged on a little late. I'm sorry, and I'm not sure this is the forum, and maybe you all can help me. But I am the Women's Health Addiction Coordinator here at CAMC. I deal mainly with the high-risk obstetrical population. Obviously, we get a lot of the chronic, SUD patients, and unfortunately, I don't have the liberty of seeing them really get into recovery. So when I see them, a lot of them are very, very sick. I do deal a lot with CPS. I have so many questions. I didn't even know that the Supreme Court was supposed to be meeting on some of this. So my question was, consistency. We see so much inconsistency in the counties. And is this going to change? As far as like urine testing, we have started testing, we have always done observed urine screenings. Our chain of command is exact. I mean, that patient does not go anywhere without their own urine. They seal it. We seal it in front of them. I can't imagine there were even chain of command issues going on in our population with what we deal with. I mean, we are so regimented about that. So I didn't even know that was an issue, but we see so many synthetics of things that CUPs do not even test. I mean, how is our state going to address that? Because, we have children coming into our ERs, I'm sure you all know, that are exposed to things, and these kids can get other things in their system other than marijuana. How is that being addressed? We have people we know that have lost custody, but guess what? They come into their next appointment and they have these children. There's no follow-up. Mama's supposed to have custody or guardianship, but Mama's 75 and is tired and has allowed this mom or dad or whoever to, live in the home, and they aren't supposed to be around, and they come to their appointments with these kids. Or guess what? It is familial, like I said in my other comment. Mama or uncle that lives in that home is using heroin or meth. Are they not tested? Why are the guardians that are taking these children in not expected to meet the same criteria of the women or parents that are trying to get custody back of their children? I mean,
So-
we are overwhelmed here, and we are so disheartened and frustrated and sad and all the above. I mean, so I saw this. I literally just signed up for this not 10 minutes before it happened, and I was in a staff meeting and logged on late. I'm like, oh my God, I got to log on, see what they have to offer me. Our social workers are beyond, just exhausted and sad and all the above. We like need some help. So I was hoping somebody could tell me something good here is going to be happening or where to go.
Well, I don't have that. So to the you're overwhelmed and exhausted, I am too, and every CPS worker is. I'm going to answer what I can. So in terms of guardians being tested, so some of that is you're walking into constitutional issues. The guardians of the kids, so when kids are taken from custody and let's say they go to a kinship placement, the department has to do a background check. So we run a criminal background check. They do a CPS background check. We cannot ask for that person to drug screen unless the court would order it. And technically they're not a party. So the court ordering it is even really gray area as to whether or not that's an infringement on their constitutional rights. So it would be very rare for the
If
court to
they've been given custody of this infant, that it's not our right to test them.
You're preaching to the choir. So I agree it's an issue. I don't know how it gets solved, and I don't know what happens there. I will say, yes, I understand there's not a lot of follow-up. Now, there is follow-up with families, or there should be, until what so-called permanency is established. So let's say rights are terminated, kids go with grandma. Until grandma has a legal guardianship or adopts, the court will continue to have hearings every 90 days, and the department stays involved, and they're supposed to have face-to-face contact with those children every month until permanency is established. Once permanency is established, until and unless another referral comes in, the department's not going to have contact with them, and nobody else is either. So I get that there's a gap there, and I don't know what or if that will ever be addressed. I have to say, and obviously this is to a group and it's being recorded, so I'm going to try to be as diplomatic as I can be in saying this. I personally, I'm not speaking for the department, I'm not speaking for WVU, I'm not speaking for anyone but myself. I personally believe that the system that we have right now is not able to address the problems that we are seeing in the year 2024. What has happened is, these systems and parameters were put in place when counties, the biggest counties in the state, may have seen 2 abuse neglect petitions a year, 4, something like that. And now we're seeing upwards of 200 and 300 or more. And instead of recreating the system, we just keep modifying what we've done. Some of that is from the feds down. So there are federal guidelines in order for the department to receive funding that they have to comply with. And I think we just haven't caught up as a country and as a state to the problems that we're actually dealing with. And I wish I had an answer for when that will be addressed. I don't know. A lot of people have a lot of different ideas of how it should be addressed. Most recently, the department had some restructuring in terms of policy. I don't really feel anything changed with that restructuring. And so I think everybody's just trying to do the best they can with what we have right now. And unfortunately, frankly, it's not enough. And I know that, you guys know that, everybody in the system knows that. And so I know that's very doomsday to say, but it's just the truth. Nobody is trying to mess things up for anybody. Like, everybody's trying to protect these kids. Everybody wants to see families reunited if it's possible to do so safely. But we don't have the resources right now to do that well or to monitor it well. And I'm not sure how we get there. Somebody who's a lot smarter than I am will have to figure that out.
I hate to do this. I know this is such wonderful discussion and such an important topic. I just wanted to kind of put out there that we are about 20 minutes over the session time. I would hate to rush anyone because it is so important talking about all of this, but I wanted to get in any final comments, questions from the group. We can always do another part 2 to this discussion without even a PowerPoint. We can just get together and have this open discussion. So Elizabeth and I can work to have that planned as well.
Yeah. I am actually, the positive from this is I think there's a lot of passion and concern and interest in solution-focused discussion. So I think that's really positive, and we can certainly have a part 2. I think that's a great idea. I just wanted to bring people's attention. Richard posted some things in the chat that I think were really helpful, maybe that could go in the wrap up. And then if there were unanswered questions, I don't know if those could be posed kind of through the wrap up to Shauna or to whoever might be able to Jennifer.
Absolutely. I can put my email in the chat as well again. And whoever has questions following up to this discussion, please send them my way. I can send those over to Shauna, Jennifer, and in the recap email as well. So there's my email in the chat. Any final comments, questions from the group? I wanted to give a big thank you to both Jennifer and Shauna for coming today and presenting on such an important, passionate topic, like you said, Laura. Yeah.
And it sounds like people would be interested in a task force. I'm not aware if there's one already, but Amanda and I are part of, and Anna are part of a group really trying to collaborate with CPS throughout the state, in addition to at the higher levels, so we can pose those to the powers that be, that we could perhaps have a task force like that. Richard, yes?
I can't post it or put a link to it, but I would recommend that people go to WV Oasis, VSS, the portal, grant funding opportunities. I'm trying to get the word out that we have a grant funding opportunity called ICAN, ICAN. You may have to go to WV Oasis, VSS, grant funding opportunity. And in the keyword search, ICAN, that stands for Impacting Child Abuse and Neglect. We are trying to open up all this Title IV funding for grant opportunities around a lot of these issues that we're talking about. Now, there are specific parameters because it is federal money, of course, but we have an MOU with DHHR, and we're trying to get, I'm just trying to get the word out as much as I can about this grant funding opportunity for this Title IV funding that other states, not all, but many states are using. And if any state needs to do something about the crisis of foster care, it is certainly ours. So please check that out, get the word out. I've already got a few organizations trying to apply.
Okay, so like wvoasis.gov, is that where to start?
Yeah, WV Oasis.
Mm-hmm.
And then you VSS, that's the Vendor Select Services.
Okay.
Yeah, and then if go to the grant funding opportunities, ICAN is the name of the grant funding opportunity, ICAN, Impacting Child Abuse and Neglect.
Great, thank you so much, and we'll try and put that in the recap too.
Great, thank you.
All right, thank you guys. Sorry for going over, but I appreciate all of the really intense discussion and care about families and kids.
Absolutely. Only announcement I have is next session is March 20th. We have Jennifer Price presenting on in-home safety planning. So keep an eye out for that reminder. I echo what Laura just said. Thank you all so much for joining, and we appreciate everyone's time. Thanks, everyone. Take care.
Thank
Bye-bye.
you.